Hello friends, welcome to Civils Forum. Today we are discussing the Hindu editorial analysis, and today's topic is about alimony. The title of the article is Alimony Guidelines, which is given by the Supreme Court. You can relate this article to the syllabus of CSE GS Paper 2, Mechanisms, Laws, Institutions and Bodies constituted for the protection and the betterment of vulnerable sections. Before beginning with the discussion, let's go through some difficult and important words which are mentioned in the article. The first word is alimony. Alimony is financial settlement, maintenance or the support to the spouse during the divorce. The second word is cobweb. It is the old and dusty spider web acquired in long time. The next word is decree, the judgment, or you can say the declaration. The last vocabulary is vagrancy, that means homelessness or migrancy. So let's begin with the article by understanding the context, which mentions the recent Supreme Court judgment and comprehensive guidelines given by the bench of Supreme Court judges about alimony. The Supreme Court judgment has covered more specific points like reasonable needs of a wife and dependent children and her education qualification, and also about her source of income and its sufficiency. The Supreme Court also mentions that the entitlement of maintenance from the date she applies for the divorce. The writer of the article has discussed some important provisions given in Indian constitutions and our legal system. Under Article 15 bracket 3, which states, nothing in this article shall prevent the state from making any special provision for women and children, which read together with Article 39 of Indian Constitution, which directs the state policy towards equal pay and opportunities for both women and men. And also the court laid down that while women can make claim for alimony under different law, that is the Protection of Women from Domestic Violence Act 2005 under section 125 of Criminal Procedure Code CRPC, and also the woman can file the request the relief from the under Hindu Marriage Act 1955. The author has shown some concerns on distress of women, as the early marriage and early bearing of child can lead to poor maternal health, which in turns the root cause of high level of child stunting and wasting in India. Here is the question for you. Please comment in the comment box the definition of stunting and wasting. Another reason which writer mentions for the distress of younger women or girl is that they are not independent financially when the marriage is broken. To avoid longer running of cases in the court in midst of large and growing matrimonial litigations, some clarity is expected for resolution of the issues. In this case, the judgment of the court can be said to be progressive, which may help to reduce the widening misery of women. In way forward, the writer talks about the laws which we discussed in earlier slides has also not suggested to direct the husband to pay the maintenance under each of the proceedings, which is inequitable in nature. In this particular case, the court has also added how its order of maintenance may be enforced under laws and section of CRPC 128. In conclusion, the writer says, despite of persistent legislations and orders of courts, the poor dependent women and children are unable to get served the maintenance they required at early stages. And the author is also emphasizing on the necessity of early enforcement of the laws to protect dependent women and the children. Thank you very much for the discussion. Have a nice day.